Good morning, everybody, and welcome. We've got a big room today, which is very exciting. So go ahead and put into the chat box where you're joining us from. We always like to see that. It's always fun. Somewhere in Riverside County, we are assuming, but maybe not. We'll get kind of settled in here. We'll give it just a minute. Hello, Palm Desert. Stephanie, welcome. Beaumont, lovely.
Oh, good morning to Temecula.
Rancho Mirage. Ooh, they're coming in hot.
Well, hey, Maine. Glad you're with us.
Awesome.
Oh, big group, lots of places.
Yeah.
Good morning, everybody.
Yes, definitely. Mississippi. Okay, now we understand something here.
Maryland looks like.
Love it. All right. Awesome. Thanks, everybody. It's great to see everybody here. So again, welcome to the 2023 Labor Law Update webinar sponsored today by the Riverside County Workforce Development Board. Excuse me, my name is Tara Brennan and I am the events manager here at CEA. And before we get started, I just want to go over a couple of housekeeping details with you. Your audio is muted, but we do love participation from you. So if you have any questions pertaining to the presentation, go ahead and put those into the Q&A box. That's down on the bar and it's to the left of the chat box. That's where Mary and Eli will be able to monitor your questions and answer them as we go. If for whatever reason you did not receive the handouts that were in the reminder emails with this link, go ahead and put your email into the chat box. That's where I will be, and I'll be able to help you out there, excuse me, with if you need handouts or if you've got any very simple technical difficulties, I might be able to help you with. There will be a very quick survey at the end of this. It'll be a QR code on a screen. If you want to just take a picture of that and take a survey for us, we would love to hear your feedback. We're always here to make these the best informational webinars that we possibly can. So with all of that said and done, I'd like to go ahead and introduce Jason Tang. He is the Employer Services Manager at the Riverside County Workforce Development Board. Jason, welcome.
Thank you, Tara. Welcome to everybody and Happy New Year. We're really excited that everyone is joining us and taking time out of your day to be part of this labor law update for 2023. This is just one of the many services that the Riverside County Workforce Development Division provides to our local employers. So please go to our website, www.rivcoworkforce.org. You'll be able to see a lot more of our services and programs that we offer, including some wage reimbursement programs, and everything is free. The programs and services that we offer, no strings attached. Do want to highlight the free HR hotline that is available to you as well, provided by the California Employers Association. As a small business owner myself with about 10 employees, no HR department, I've actually used this service on behalf of my business, and it's really, really wonderful. When you call, they ask you, what your question is, and based off of the topic that you have, they direct you to one of their subject matter experts. My question was about, what you can and can't have on an application. And so they were really helpful with that. And I ended up making some changes based on that call to our application. So keep this number handy, use it often so we can keep providing the service to all of you, our local employers. So we hope you enjoy this seminar. This is the fourth one that we've done with CEA, and they do a fantastic job. And I look forward to learning alongside all of you as well. So welcome and thank you, Tara. I'll hand it back to you. You are muted, though. Tara, you're muted.
You're muted.
Here I am. Sorry about that. I did notice that there's some people that are looking for the handout, so I will email those out to you. And thanks, Jason. We're thrilled to have you here and everybody else. And now I'd like to introduce our presenters. We have Mary Bradford and Eli Nunez. They're both directors of HR here at CEA. Folks, it's yours.
Great. Thank you so much, Tara. And thanks, Jason, for the intro. Really glad to be here with you today to chat with our friends in Riverside County. My name is Mary. I'm going to be doing the first half of the presentation, and then Eli will be taking over for the second half. So as Tara mentioned, please put any questions you might have for Eli or myself in the Q&A box. That is where we will be monitoring for any of your questions. And then if you have technical issues or if you do need those handouts, go ahead and put your email in the chat box for Tara. That's where she will be. All right, well, let's go ahead and get started. So yes, as Jason mentioned, you have an amazing hotline that Riverside County is providing to you, and that is your main hotline number. You will notice on our slides, we have a different 800 number. That's the main number for CEA, which I'll tell you about CEA in just a second. But we do ask that you call the Riverside specific number, so then we'll know where you are calling from. But just as Jason said, you can call and ask any HR related question. If it's about what should be on an application, if it's about wage and hour, if it's a leave of absence question, we are here to help you and try to make your life a little easier. That's our goal, to bring you peace of mind and to try to make these crazy laws in California a little understandable or more understandable and a little more user-friendly, because some of them can be very complicated and intertwined, and we'd like to try to help you figure them out. So that's our job. And we do that through providing, we've got the hotline for you in Riverside County. We also do a lot of other services. We can help you if you need help with a handbook, if you need someone to come on site to do some training, or if you just need a little extra HR help, we can help you with that. Now that would be above and beyond the hotline. Eli's gonna show you a slide on that later about if you need an individual membership, but the hotline you have is Monday through Friday, 8 to 5. Give us a call anytime you have those questions, and we are more than happy to help you out. We do also have a great website, which is employers.org, where we have lots of really good tools out there for you. A lot of them are available for everyone. There are some areas of the website that are member only, but we can certainly kind of direct you to a couple of areas where you can get lots of resources on COVID, for example, fact sheets on hiring and firing, all that kind of good stuff. So definitely check out our website and take advantage of those resources that we have out there. The other thing I do want to remind everyone, Eli and I are not attorneys, and CEA is not a law firm. So please don't rely upon what we're going to talk about today as legal advice, even though we're talking about assembly bills and laws and all of those good things. Keep in mind, you should always have an attorney available to you, or that you have their number for in case you do need them, because we do live in California. It's a beautiful place, but it is a litigious place. So not a bad idea to have an attorney. We do have attorney partners on our webpage. If you ever need a resource, I hope you don't, but if you do, those are always available for you, that you can contact them as well. All right, so here's what we're going to be talking about for the next 80-ish minutes or so. We're going to talk about all the new things that have come to California employers for 2023. You've probably been hearing quite a bit about pay transparency and a couple of changes that you're going to need to make to how you do things and how you post jobs. We're going to talk about some changes to leave laws. We've got the California Family Rights Act and paid sick leave that have gone through some changes, as well as the new bereavement benefit for your employees. Then we're going to talk about wage and hour, minimum wage, exempt salary, all of those good things before we wrap it up with some industry-specific laws. All right, here we go. So let's start with our employee leaves, rights, benefits, all of the things that our employees can get. Here are kind of the four main changes that you need to think about for 2023. Pay transparency that I mentioned, some changes depending on your employer size. You're going to have a couple of different things to consider. We have a new unpaid bereavement leave benefit for employers in California. We also have something called designated person that will apply in paid sick leave benefit, as well as CFRA, that's that California Family Rights Act. And then we have a new protected category in California, reproductive rights. So let's take these one by one. Pay transparency. All right, so as you may recall, in years past, you as an employer have needed to provide the pay scale to an applicant when they would come in to interview for a job. So normally after that first interview, they could contact you and say, well, yes, I'd love to come back for a second interview, but can you give me an idea of the pay scale? Well, they've expanded that a little bit. So now you need to also make sure that you are providing the pay scale upon request from your current employees. So if a current employee comes into you and they say, I know I'm an IT tech too, and I make $45,000 a year, but can you tell me what the range is? What is the range that you pay all of the techs in this company? And you will now be required to disclose that information. Now, you don't need to include information on total compensation. So if there's bonuses, tips, commission, that doesn't have to be included. So what you're really including are those base wages or a range where somebody would be paid if they work in that particular position. The other new thing you need to do is start maintaining a wage rate history for all of your employees. Now, this does not have to be very complicated. And for many of you, if you're using an HRIS system, it probably already does this for you. But if you don't have that, not to worry, you can just set this up in an Excel spreadsheet. But what you want to start doing is tracking the wage rate history for each of your employees. And you need to make sure you're doing that effective as of January 1st. So put this on your New Year resolution to do now list as you're going to start putting into a spreadsheet or using your system to put the employee's name, you're going to put their pay rate, and you're going to start keeping track of that so that you've got a record for that. Now, you're also going to want to make sure that you hold on to that information 3 years after an employee leaves you. So again, this is one of those record retention requirements. Normally, when it has to do with payroll, timekeeping, record keeping, you always want to keep everything for at least 3 years because that's how long an employee can make a claim. If they ever go to the labor commissioner, it's 3 years from the date of that claim. So make sure you hold on to those things for at least 3 years. Now, the other change, if you're a larger employer, if you have 15 or more employees, you now need to include this pay scale for a position when you are posting a job. If you're doing it on Job Jupiter, if you're putting it on Craigslist, if you put it in a newspaper, you need to include the pay scale for that position. So a couple of other states have already been doing this. So if you're a multi-state employer, you're probably familiar with this. But anytime a job is posted in California, or if a California employee could do that job, if they could apply for that job, you're going to want to make sure you're now putting that pay scale information. So again, it could be we're looking for an IT tech level 2. The pay scale is 40,000 to 50,000, but you need to include that information in the job posting. Also, you want to make sure if you're using a third-party recruiter that they are also including that information. Some out-of-state recruiters would not be familiar with this, so you've got to make sure if they're posting for you for a California position, or again, someone from California can do this position, then that information needs to be posted in that job listing now. So what are we going to do for our next steps here when it comes to pay transparency? Because I know this might be a big change for a lot of people. So the first thing you're going to do is you're going to start creating those records of job titles, the wage history for every employee. And again, you don't have to go backwards. You're just going to start from January 1st of 2023. You also want to make sure that you've got proper record retention. There are a lot of rules when it comes to record retention. I can tell you in general, a good rule of thumb is to retain records 4 years post-termination. 7 years is even safer. But for this particular requirement, you're supposed to hold on to it for at least 3 years post-termination. Now, again, if you have 15 or more employees with at least one employee in California, you want to update any job descriptions, or job postings with that salary information and make sure if somebody else is posting for you, they're also including that. There are some heavy fines if you don't include that information. So it's a good practice to make sure you are. And if you're not sure about particular positions and how much you should be paying, we've got a couple of resources for you. We have a partner who does compensation surveys. There's also a lot of online resources, or many of you might already participate in salary surveys where you might be able to gather up some information to really determine what is the average weighted pay that an individual is making in a particular position. And you can develop your salary ranges based on that. Sometimes we get questions about, gosh, I don't want to put the salary range in this posting. I don't feel right about that. But I would encourage you, it can actually be a really positive benefit for you as an employer, because it can just be a way of weeding out potential candidates that just aren't going to be right for the position. So again, if you're looking for your IT tech level 2 and your range for that position is 40 to 50, and somebody's looking for a job and they won't go below 70, then they're probably not going to apply for that job because they're going to be outside of the range. So it actually can save you quite a bit of time as you screen all those resumes that you might be getting that people should be paying attention to the range, and it's kind of a nice way to filter out some people that maybe just aren't the right fit for your organization as far as their compensation needs. So something to keep in mind for that. So we have our first poll up, and Tara, I'm hoping you can run that for me. I don't believe I've got the poll button up. Would you be able to start it for us? And here's our question. We're just kind of curious what everyone has been doing in their own practice. So did your company include pay scales in job postings prior to this new law passing? So before January 1st, did you post your pay scales? And I'm not sure, our poll may not be working. Sometimes Zoom is a little cranky, but if you just want to go ahead and put into the chat box, yes, we always did that. No, we never did that, or we only did it for select positions. We would love to just kind of see what everyone used to do for that, because it is kind of interesting. Yeah, it looks like, thank you so much everyone for the chat. Kind of 50-50, we get a lot of that, a lot of yes, a lot of no's. And yes, for some positions, sometimes for lower level positions, we do see that a little more frequently. And sometimes the starting salary, yes, absolutely. So great. All right. Thank you so much, everyone. I appreciate that. Yeah. So some companies have been doing it for a long time, especially if you're a multi-state employer. I know more companies are familiar with it, but it's just a new change for California. But I think once everyone gets used to it, I think it'll actually be advantageous for everybody. So let's start talking about the new bereavement leave. So this was a big change for California. It's something they've been talking about for quite a while, but it finally went into effect. So if you have 5 or more employees in California, you are now required to offer your employees unpaid bereavement leave upon the death of a covered family member. And I'm going to show you who those are in just a moment here. In order to be eligible, the employee must have worked for you for 30 days before that leave, the date that they're requesting for leave, and the employee must use it within 3 months of the date of the death. Now, the other kind of different change with this is that employees aren't required to use the time consecutively. So often what can happen is if somebody passes away, maybe the employee needs to take a day off immediately to deal with any of the family issues, but then perhaps the service wouldn't be until the following week or maybe even the following month, depending on the circumstances. So this just gives your employees an opportunity, if they need to break up that time a little bit, that they're able to do that. Now, you as an employer can definitely request appropriate documentation. That can be a death certificate, a copy of an obituary, anything like that. What I would remind you is that consistency is key in California. So if you ask one employee to provide documentation, make sure that you ask all employees to provide documentation, just so you're being consistent with that. We don't want someone feeling that they're being picked on and only they've been required to provide documentation when other people have taken that time off as well. So this is your first reminder about handbook updates. You definitely want to update your handbook with this policy. Also, make sure you make any adjustments to any forms that you have in regards to bereavement leave. And also just a reminder too, if you need a employee handbook, we have a great DIY template out on our website under our CEA store. We've written it, the team has written it, so it's very user-friendly. Sometimes attorney written handbooks can be a little difficult to digest, and ours is much more user-friendly, and it's in the first person, it's very conversational, but we have all of these new policies in that handbook. So if you need that, go take a look at it. It's out there for you. All right, a couple of other things on bereavement leave. Keep in mind, bereavement leave is unpaid. So you as an employer are not paying the employee for this time, but the employee can use their vacation, they can use their PSL, their paid sick leave, they can use PTO. Now, you might already provide a couple of days of paid bereavement leave, and that's fine. You can absolutely continue to do that. So maybe an employee needs to take 5 days, they're entitled to up to 5 unpaid days, but perhaps you just pay 2 days. So you can keep that policy if you would like to do that. Now, keep in mind with bereavement leave, the state requirement of the 5 unpaid days is per death, not per year. So if an employee, for example, needs some time off in February, if a family member passes away, hopefully they don't have to do that again, but if they do, say they need some time in November, they would be entitled to another 5 days of unpaid leave. But you, if you have a paid time off policy or a paid bereavement leave policy, you can just stipulate that it's 2 paid days per year if you would like to do that, or you can say 2 paid days per incident. Totally up to you. That is at your discretion. Now, of course, as an employer, we always want to maintain confidentiality. If anytime somebody is taking time off, if somebody says, hey, where's Mary? I haven't seen her in a while. We don't want to disclose where an employee is unless that employee has given us permission. So if it's a medical issue or if it's taking bereavement time, it's much better just to always say, oh, they're taking a couple days off. We expect them back next week. That's all I can say. And then we can leave it up to the employee to disclose any of that information. Now, when it comes to covered family members, we've got the list there for you. It's spouse, domestic partner, child, parent, parent-in-law, sibling, grandparent, or grandchild. So those are the covered reasons. You might have different provisions for paid bereavement leave. That's perfectly fine. But when it comes to this new unpaid bereavement leave, you do want to make sure all of those covered family members are listed in your policy. Let's transition over to CFRA. Now, Eli and I are in HR, which means we like a lot of acronyms. You're not living if you're not using a lot of acronyms in HR. And CFRA is one of the big ones, and that stands for California Family Rights Act. Now, this applies to you if you have 5 or more employees. And this provides employees with up to 12 weeks of unpaid leave and guaranteed job reinstatement at the end of the leave. Now, anytime an employee is on a protected leave, when they are on CFRA, if they're on pregnancy disability leave, or if they're on FEMLA, if you're a larger employer and deal with that, benefits always continue during the leave at the same level they were at prior to that leave starting. So if the employee pays 50% for their benefits, they pay 50 and you continue to pay 50. So we always keep benefits in place during a protected leave. Now, when it comes to CFRA, employees do get those 12 weeks of unpaid leave, and that's within a 12-month period. That can be a calendar year, that can be a fiscal year. Most employers use a look-back period where they look back at the prior 12 months to see how much time an employee has to take for CFRA when they request it. Now, they're eligible to take CFRA if they have worked for you for 12 months, and in the prior 12 months, they've worked 1,250 hours for you. Now, keep in mind, CFRA does run separately from pregnancy disability leave. That's PDO, as you may know it. Now, when it comes to being a CFRA covered employer, excuse me, you do want to make sure you have a policy on this. You've got your poster up in your workplace and you are using the state of California's forms. We never want to use Fed forms when it comes to California CFRA, because a lot of the Fed forms ask for information that you are not allowed to ask for in California. So always make sure that you are using CFRA or California Family Rights Act related forms. Now let's take a look at the reasons that people use CFRA. So it's very commonly used for baby bonding, and this would be after pregnancy disability leave. And that's when they have a child or if they are adopting or bringing the child foster care into their home. An employee can also use it for their own serious health condition, but remember, pregnancy is not covered under CFRA. If they have a family member in the armed forces, if they have somebody who's on active duty, they can take time off to care for them. And also family care. So if they are caring for a family member with a serious health condition. So that's kind of just an overview of CFRA. So I know a lot of you are probably new to CFRA. It just started being covered for smaller employers in the past few years. Before, it used to only apply if you had 50 or more employees. So that's why we wanted to kind of give you an overview, because people are still a little thrown off by CFRA if you're a smaller employer, but that does apply to you if you have 5 or more employees. So here's the big change with CFRA, which also affects PSL, your paid sick leave program. They have now added what is known as a designated person to a covered reason in CFRA as well as paid sick leave. So an employee can use paid sick leave or CFRA now to care for a designated person. So that means an employee can come into you and they can say, I need to take 6 weeks off to care for my roommate because that is my only family that I have. And this was really kind of established for people who might be immigrants, who maybe don't have any family here. Maybe they are a person whose family they don't associate with anymore. And so they might have a different individual who represents family to them. They are therefore able to take time off to care for them. Now, the employee does need to make this designation at the time of request, and you as an employer can limit to one designated person per year. So when an employee comes in and they say, I need to take care of my roommate, you can say, okay, that will be your one designated person for 2023 or for the calendar year, fiscal year, whatever year you're using for that. So this is another handbook update. Make sure in your CFRA as well as your PSL policy, you list designated person as a covered individual that someone can take some time off for. So here's where it got a little tricky with the state of California. They did not use the same definition for designated person for CFRA and PSL. Yes, I wish they had as well. But under CFRA, the definition is in any individual related by blood or whose association with the employee is equivalent to a family relationship. So that's CFRA. PSL is a little more broad in general. This is a person identified by the employee at the time the employee requests paid sick days. So it's a fairly generous definition. If you want to use the same definition for CFRA and PSL, that's fine, or you can use those separate definitions. Now, what I will tell you, because we might get this question, is does this apply to bereavement leave? At this time, it does not. We're not entirely sure why they didn't include it. Chances are, though, that will probably be a change we'll be talking about in the next year or two at a labor law update, that they have added designated person for bereavement leave, but we'll see. As of now, it's not in there. It only applies to CFRA and PSL, but we'll see if that changes. All right, let's talk a little bit about reproductive rights and how this is a new protected category in California. So FEHA is the Fair Employment Housing Act of California, and that is the act that lists the different protected categories in California. They have now added reproductive health decision-making as a new protected classification in California. So that means you as an employer can't ask an applicant or an employee to disclose any sort of reproductive health related information. I'm not sure many of you are doing that. We would certainly have discouraged it in the past, but now it would be a violation of FEHA, which is much more serious. So this means this is another policy update for you. So in your harassment prevention policy, you're required to list all of the protected categories in California. You will now want to add reproductive health decision-making as one of those categories. So that means you couldn't make any decision if you found out that somebody was using a particular drug or birth control method or anything like that. So reproductive health choices are now protected in California. All right, a couple of takeaways for you from some of those interesting laws I got to cover there. All right, so you're going to make sure you're going to work on, excuse me, creating your job title and your wage rate history records. You're going to have a couple of policy updates here, right? You've got your bereavement leave if you have 5 or more employees. For CFRA, you're going to add in that designated person, CFRA and paid sick leave as well. And then any FEHA EEO policies for that reproductive rights is now protected. And of course, always make sure you have an updated poster. A California and federal all-in-one poster is the way to go. If you need one of those, you can check out our CEA store. We have those available for you. We have them in English and Spanish if you need those. And we also have other states if you need that as well. Let us know. But if you do need help with a handbook and you're thinking, oh my gosh, that's a lot of updates she's already talked about, and Eli hasn't even started talking yet, just give us a call on the hotline, let us know. You can also, we've got a bit.ly here for that labor law poster, and there's information on there about handbooks too if you need some help with that. So just let us know. All right, let's get into some other things now. Let's talk about wages. All right, if you joined us in years past for our labor law update, you remember this was a much more complicated slide because we used to have small employers, large employers, based on your company size and what year it was, what wages you had to pay. Well, it's much easier now. So now in the entire state of California, the minimum wage is $15.50 an hour, which means the exempt employees in California need to be making at least $64,480 a year. So you might be thinking, wait, I thought it was just going to be $15 an hour. There is a provision in the state of California that if inflation goes over 7-point-something%, that the minimum wage has to be adjusted accordingly. So that is why it is up to $15.50 as of January 1st. So we always want to make sure we're paying our employees minimum wage. There are very hefty penalties if you do not. So make sure that you're always paying minimum wage. Now we have a lot of states in California, cities in California that have their own local minimum wage requirements. And I know we have people from all over, so you might be working in a different city or have employees in a different city that has a different minimum wage. So this is why we always encourage you. You need to know where your employees are working, because there's about 35, I think we're up to 38 now, different local minimum wages. We have a bit.ly on this slide for you that takes you to a cheat sheet that shows you the minimum wages as well as the paid sick leave requirements. We have a couple of cities that have their own paid sick leave requirements. So make sure you're checking those out. Excuse me. Also, make sure if your employees are working remotely, you know where they are working, so you can ensure that you're paying them properly for the area that they are working in, not just where your office is based. All right, we've got another poll for you here. Is your business impacted by local wages? So you can go ahead and just, again, pop into that chat box. Just let us know if you as a business have to deal with multiple local minimum wages, or if you can put no, that you're just dealing with the state of California. We'd like to see how many of you are dealing with that. See a lot of no's. I'm guessing those are our local Riverside friends. Riverside County has kept it under control. We appreciate that. And it looks like Eli is back. Do we have some questions, Eli?
Yes, Mary. Just a quick one. Basically a question about whether the city minimum wage supersedes the state, which typically, I mean, the city or the municipalities could be higher than the state. So yes, it would supersede it. However, just want to point out, keep in mind that for exempt employees, we're still using the state minimum wage as the basis for their minimum wage.
Great. Yes, absolutely. Yeah. So the exempt wage is based on, they take the state minimum wage, you multiply it by 2, and then you multiply it by 2080, which is the number of work hours in a year. And that gives us our exempt base wages. So keep in mind, yes, just as Eli was saying, it doesn't matter if a particular city has a higher minimum wage when it comes to exempts, you just always look at that state minimum wage.
And then the other question we had was salary requirements for salary non-exempt, which I believe would be just that's the minimum wage if you're salary non-exempt. But I want to see what your thoughts were on that one.
So salary non-exempt used to be a fairly popular term a couple of years ago. We kind of don't like it because I think it leads to confusion. So if you have an employee who is salary non-exempt, keep in mind they're still non-exempt, which means they need to clock in to start their day, they clock out for lunch, they clock back in from lunch, they clock out from the end of the day. And then that also means on their pay stub, you are listing every rate that they're receiving and the number of hours they worked at that rate. So I would be cautious about what the downside, and tell me, Eli, what you've seen, but the downside is I think people sometimes think, oh, I'll just pay him a flat salary, but I call him non-exempt, which is not going to work for you in the state of California. So I would give us a call at the hotline. We would be happy to chat with you about maybe just starting to call them non-exempt and getting rid of that salaried word. We really just like to keep salaried with exempt. I think it's a little cleaner.
Yeah, absolutely. I agree. I mean, when you factor in the break times, lunch times, and overtime, it makes it very complex. So
yes, and misclassification, it's very, very expensive. I'm working with a member right now who misclassified somebody, and they're looking at a $39,000 fine with the labor commissioner, and they're just getting started. So it just goes up from there. Very seldom goes down. So yeah, give us a call. We'll be happy to chat with you if you need to talk it through. And it looks like we had another, I just happen to have the chat box opened. What if an exempt employee is required to work more than 40 hours? So exempt employees, if they are properly classified as an exempt employee, which means they meet all the duties as well as the salary requirement, there are not hour restrictions. So an exempt employee could work 60 hours a week, or they could work 20 hours a week. They would receive the same salary. So you don't have to worry about overtime. You do have to worry about somebody being misclassified though. So we always recommend you check that misclassification. All right. Thank you, Eli.
Mary.
All right. So another little carve out here for any of you in the medical field, or I've been talking about IT a little bit. They have a couple of their own requirements when it comes to salary. So in order to be a exempt salaried physician or surgeon, you have to make over $97.99 per hour. So that's a big change. Computer software professionals, Keep in mind, this is an area that we do see people misclassified, computer software professionals. You have to be a very high level computer software person to be exempt. So this could be a webmaster, this is your director of IT, a general IT tech will not meet the classification most likely because they have to make a minimum $112,065.20 per year. So take a look at your IT people and how you have them classified. Most likely they should be non-exempt unless they're, again, a very high level IT individual with your company. Mileage reimbursement. Let's chat about this because this is a big change. Gas for us has finally come down to the low 4s, which has been delightful. I know everyone has been feeling that in California. But every year the IRS releases what they say is their suggested mileage reimbursement rate. As of January 1st, it is 65.5 cents per mile. So that means when your employee is using a personal vehicle for work, so if you're sending them out to go to the bank to go do a deposit, if they're using their personal vehicle to travel to work sites, you need to reimburse them for that cost. If you reimburse the IRS rate of 65.5 cents per mile, that is the way of saying, I'm covering mileage for gas and wear and tear and insurance and all those kind of things. If you pay less than that, you could potentially be on the hook. So you want to make sure, we always advise, always pay the IRS rate because that absolves you of responsibility when it comes to insurance, wear and tear, gas, or anything like that. So we always advise that. Of course, workers' comp would still apply if an employee is traveling for you and they're injured in the course of traveling. But as far as if somebody says, well, I got a flat tire, I want you to pay for a new tire. If you're reimbursing that 65.5 cents per mile, that's when you say, well, we're covering the cost of that in that reimbursement. Therefore, we don't owe you anything extra. So we always recommend to go with the IRS rate. It does sometimes change in the middle of the year, so keep an eye out for that. You never know. All right, time rounding. We get so many questions on this on the hotline. So you might be familiar with a couple of cases. Of course, we all know See's Candy. They had a big case back in 2012 where they kind of established that rounding to the nearest quarter hour or to the nearest 5 minutes was allowed, as long as it was not a detriment to the employee. So basically, if an employee clocked in at 8:05, for example, you could round back to 8 o'clock. And if they clocked out at 5:05, then you would round back to 5 o'clock and it would kind of balance out. Or if they clocked out at 8:10, you would round forward, or excuse me, 5:10, you would round forward to 5:15. So it would balance out for the employee. And that was the general consensus. You could round to the nearest quarter hour as long as it was fair to the employee. But of course, that meant that you as an employer should be auditing time to make sure it was fair for the employee. If they lost a little time in the morning, they gained a little time at night, and it all kind of balanced out. There's been a lot of litigation over that. A couple of months ago, a ruling came out saying that you could no longer round meal periods. So some employers were, say somebody clocked in after a 27-minute meal period, they would just round it up to 30 minutes and say, oh, close enough, you're at 30 minutes. Well, the state came and said, absolutely not. You cannot round meal periods. Well, then we just had this big Home Depot case where employers, specifically Home Depot, are rounding time, even though their system allowed them to track to the exact moment that an employee clocked in or out. And so the court said, well, why are you rounding when your system can take into account when an employee actually clocks in or out? And so as systems have improved and technology has improved, it's much easier to capture that actual clock in, clock out time. So the California Court of Appeals said, I don't think that's the right thing to do. And they've invited the Supreme Court to answer whether rounding policies are permissible when a company can capture the actual time. So what this all means is that we advise you to stop rounding. We think rounding is coming to an end. We've seen it on the horizon for a while, and we think it's here now. So we would advise you to stop rounding, especially if your timekeeping system can already capture the exact time that somebody clocks in and out and you don't have to round anyway. So we would recommend stop rounding. It's much safer. We think this is probably going to be a big case coming up in the future. So the sooner you can change that practice, the better for your business. So let's talk about premium pay for a little bit. Let me tell you, first of all, what premium pay is, because you may call it something different in your organization. When one of your employees misses a meal break, for example, remember all of our employees are supposed to clock out for a meal break before they've completed their 5th hour of work, which is basically before they've worked 4 hours and 59 minutes, they need to be clocked out. So say, for example, somebody worked 6.5 hours, they didn't take a meal break. You would owe that individual 1 hour of premium pay because they did not take their meal period, or perhaps they didn't take a rest period. So a question came along and they said, well, these premium payments that we have to make for our employees when they miss a meal break or they miss a rest period, are they considered wages? And we just had a big court case on this last year that said, yes, those are considered wages, which means anytime you are paying your employee a wage, they need to show up on the pay stub. So you want to make sure this is now included on your pay stub if you weren't doing that before. You also want to make sure it's a separate line item, because you as an employer want to be able to show, oh yes, you missed 1 break and 1 meal period, therefore I've paid you 2 hours of premium pay. It's right here on your check. Sometimes employers were just kind of lumping it into the wages and it wasn't clear an individual had received that premium payment. And you want to be able to show that, especially if an employee goes to the labor commissioner and they say, I never got that premium payment. You want to be able to show, yes, indeed, we absolutely did pay you that. Because when you don't pay your employees all the wages that they are owed, you can be looking at waiting time penalties. So we always want to make sure we're being very timely with our employees. We've got a great fact sheet on what the regular rate of pay is. I'm going to show you a sample of what a paycheck should look like here in just a second. But you always want to make sure you're calculating the regular rate of pay correctly, and you are also listing that premium pay on your checks. So there's a bit.ly for you on this slide, but let me show you on this slide what an accurate wage statement should look like. Now, I know some of you may not check your stubs all the time. I would really encourage you to do that. A lot of payroll companies have a hard time keeping up with California laws, especially if it's an out-of-state payroll company, and they kind of sometimes miss these things. So you want to make sure that you've got all of this information. You've got the hourly rates, you've got the name of the employee, you have the legal entity name of the employer on that. Again, make sure we don't have the employee's entire social security number. It can just be the last 4 of their social security, or if you have a different employee ID number, that should be on there as well. But what you'll see over here in this earnings area is we've put it in red here for you. You don't have to put it on red in your checks, but just to point out, you now want premium pay to be listed on the pay stub as some of their earnings. So make sure that that is listed on your pay stub. I also wanted to point out to everyone here at the bottom, paid sick leave. Keep in mind, if you were a larger employer, 26 or more employees, you were dealing with something called supplemental paid sick leave. That expired December 31st of last year. So please make sure you take that off of your pay stubs, because employees no longer are entitled to supplemental paid sick leave. So you don't want it showing up on their pay stubs. But you do want to make sure paid sick leave shows up down here. So you want to make sure that you are showing the accrued unused time off that is available to an employee for paid sick leave on their pay stub. If you don't show it on their pay stub, you need to provide them a written notice each pay period what their paid sick leave balance is. So don't forget to do that as well. Very, very important. All right, let me give you a couple of more takeaways here. Make sure you are checking with your county and city for those minimum wage laws, and also if there are any special paid sick leave requirements. I think we've got about 6 or 7 cities that have their own paid sick leave requirements, so be careful with that. Make sure you are paying the regular rate of pay for penalty pay, because again, that's when an employee is owed an extra hour of pay if they're missing that meal period, missing that break, and that needs to be paid at their regular rate of pay. And then we're going to make sure we reimburse our employees the IRS rate anytime they're driving for company business in their own vehicle, and definitely audit your employees' pay stubs for compliance. You want to make sure it has all of those things listed that I just showed you on that slide, so you can make sure that you're keeping up to date with all of those rules. All right, well, I am going to turn it over to Eli here as soon as I stop sharing my screen. There we go.
Thank you, Mary. A couple more questions floated around out there before I begin here.
Sure.
First one was, if we have employees that go to multiple sites as part of their job, would that still be compensable? So if they come to the office in the morning and then go to the job sites, are we still looking to compensate them for their travel, or
Yes.
what's
Great question. So yes, employees traveling between job sites is compensable time, and they need to be reimbursed for that mileage. So usually the first work side of the day, so if they need to come into the office, that is their regular commute. That time is not compensable. But once they leave that office to go out to other job sites, yes, that time is compensable, and that mileage would need to be reimbursed.
Great, great. And let's see some other ones. Rounding question. I mean, we have a person that says, what if you round in favor of the employees on both ends, both in and out, and not rounding for meal or rest? I mean, our recommendation would still be just pay the exact time.
Right.
If you're gonna go through the trouble of rounding, you might as well pay the exact time just to clarify it, make it, stay out of trouble in any of those situations.
Yep.
Couple other ones. Let's see. As far as the penalty payment for missed meal breaks, what's your recommendation on how they should indicate that on the pay stub? Should they say penalty? Should they say premium? What do you think is the best practice for that?
Right. And it really can, most payroll systems will have something in there that designates premium pay or penalty pay. I don't think there's an official name it has to be called. You just want to make sure that you can show, yes, we made you work through your lunch, and yes, we paid you another hour. Therefore, we don't owe you any extra time. So if you want to call it penalty or premium, I think it's your discretion.
Absolutely. And something to keep in time too, that penalty or premium pay or whatever it is, that would not count towards the overtime calculation for the week too. That was another one of the questions that came up too,
Good question. Yeah, I didn't say that. Thank you.
For that. Let's see, a couple other ones are still popping in, but I may carry on with the presentation if you're okay with that, and I'll let you jump on
everybody
those.
throw your questions in the Q&A, and I will be answering you there. Thanks, Eli.
Great. Thank you, Mary. Thank you for all that great information. We will carry on here with a little bit more for you. So next topic I'd like to cover here is employment forms. And as you know, every year, when things come around, forms get updated and forms change. So let's take a look at some of the changes that we have coming up for this year. And the first one, of course, is to the I-9 form. If as most of us know, or if we work with I-9s on a regular basis, you can see that the current one that we're using has an expiration date of October 31st, 2022. So no need to panic, right? I mean, just because that form says it's expired, thing to keep in mind is that the DHS, the Department of Homeland Security, has not published the new I-9 form yet. So we're also still okay to keep using the one that says that it expires October 31st, 2022. If you're using one that says expiration date before that, then, maybe we want to update to the most recent one. But thing to keep in mind is that they're working on the new form. And from what we understand is it should be a simplified form, right? As we know, the current one is not terribly complex, but does have a lot of sections that aren't always used. It's a front and back page, sometimes multiple pages. So they're trying to simplify it a little bit to make it easier for us as employers and for employees to fill out too. So once that form is ready to go, they'll publish on the Federal Register to put everybody on notice that the new form is out, so we can all switch to it now. With I-9s, as you know, there's no need to go back and basically throw out all your old I-9s and put all the new ones on new forms. We're not going to do that. This is just a new form we're going to use for any new incoming employees going forward. To go along with the I-9 to kind of stay on the same theme, one thing that COVID did bring us was a little bit of flexibility as when it came to verifying documents for I-9, right? And this started back as early as March of 2020. Basically, what ICE and the DHS says was any employer or workplace that's operating at 100% remote, due to COVID, of course, they would allow them to verify documents remotely. And the whole thought of that was that, this was a temporary thing. And once all employees came back on site, then they could be verified in person again. So, this deadline kept getting pushed forward, what the thought was that this is going to resolve, the situation is going to resolve, everybody will be back in the office soon. And, here we are 3 years later, some of us still working remotely a lot of the time. So, as of today, that remote document verification is still available to employees. However, it's available to employees that are 100% remote. So if you do have a, a home office that people come into, 2-3 days a week, and, you work in and out of there sometimes, you still have to do the regular verification of documents where they come in, they show you their documents from the list, you take a look at them, hold them, make sure they're real, and that sort of thing. So many employers took this flexibility as interpretation, say, hey, if I hire somebody across the country, I don't have to look at their documents because there's that I-9 flexibility. Doesn't really apply if you do have on-site operations. So keep that in mind. This carve out of this exemption was just for specific COVID related situations. Moving on, we have SB 1162, which was affected paid data reporting. And most large private employers already had to do some kind of reporting every year, right? And this was done to the DFEH, the Department for Employment and Housing, as it was formerly known. California went through a rebrand of the department, and now it's the Civil Rights Department. So basically what SB 1162 did was it changed the requirements relating to what the paid data reporting is, right? Basically who has to report, what needs to be reported, that sort of thing. So a little bit more about it, though, before we talk about what these changes were. Just a little refresher. As you know, that pay data is you kind of take a snapshot of what the previous year's pay was. So it could be a pay period in the last quarter of the year, right? You could choose a single pay period. You could use a month. You could use a whole quarter, whatever it is. You're taking a snapshot of your pay information for your team during that time. That's for each establishment, and it's got additional information on there. You have to report your employees by race, ethnicity, sex, and then for defined job categories and certain pay bands in there. So this kind of goes along with that the pay ranges that Mary touched on earlier in the presentation as well. Question we get sometimes is, well, what if people don't report what their race is or their ethnicity or their gender? How do we decide? And there is guidance for that on the Department of Civil Rights page on how to do these reports. Typically they ask you to make a estimate or to make an educated guess as to how you categorize everybody, right? Or leave them uncategorized if that is an option there. So calcivilrights.ca.gov is the website where you'd be able to find some additional information for it, a user guide, how to report, that sort of thing. And keep in mind, this pay data is based on basically what you're going to report in the W-2s for the year. That's why we're looking at that last quarter, because everything should be wrapped up by then. Hopefully you have all your reporting done for the upcoming year so you can pull the numbers out of there. Okay. Now, some of the revisions that were made by 1162 included all employers with 100 or more employees now have to file this report. It used to just be if you were required to file with a federal EEOC, then you had to file with the state. Now it's all employers in California with 100 or more employees have to file. Now, this deadline for reporting is the second Wednesday of May of every year. So this year that falls on May 10th. Mark that on your calendar. If you have one of those desktop calendars, put a big red circle around that. Make sure that you have that report submitted by then. That's usually, you can submit that online. So to try to simplify it as much as possible. And for any of those of you that are fans of statistics, now we have to include the median and the mean hourly rates for each of those combinations, for each of those groups that we're going to break down the data into, right? Of course, median, that's the midpoint of the wages or the pay, and the mean is the average. And as with anything that is required by the state, California wouldn't be a requirement if there weren't any penalties involved, right? If we don't file. So make sure you get that filed on time. Otherwise, you could be looking at $100 per employee for failure to file, and subsequent violations double, what we're looking at. Now, this wasn't all bad news. They did simplify some of the provisions for reporting. So if you're an employer that has multiple establishments or multiple locations, they deleted the provision that requires you to consolidate all the information into one report. So you can just do one for each different establishment under your umbrella. And If you hire 100 or more employees through labor contractors, those have to be filed through a separate report for those employees. So, any organization that has extensive use of labor contractors or, a labor workforce or a temp labor workforce, sorry, or a contractor workforce, that's got to be a separate report as well. Okay, carrying on a little bit along the same vein, we have transmissible diseases and safety in the workplace. If you were part of any of these presentations last year, you know that this section was very much COVID oriented or very COVID heavy. There is still quite a bit to do with COVID on this, and basically this whole section is a result of that, right? As you know, a lot of the regulations, we may have mentioned in the past, regulations, changes, and measures put in place were not going to go away even after COVID was gone, unfortunately. So what we have now is AB 2693, which relates to COVID reporting, right? And some things are still the same. If you have an exposure at your workplace, you still have to provide your employees notification of that COVID exposure, any employee that was affected, within 1 business day, right? What AB 2693 does, though, is it extended these notification requirements until January 1st of next year. So there was thought that maybe, once the year wrapped up, this would go away. They'd start rolling some of these things back, but we were looking at least 1 more year of it. So, keep in mind, I mean, we're still reporting any of these exposures to employees. We're still tracking these things, making sure that we're following our COVID prevention plans and that sort of things. And of course, certain cities, certain areas may have different requirements. So be very aware of your local ordinances. Make sure that, you're following those procedures. As with anything else, if your local ordinances are more strict or have more requirements than what the state does, those are the ones you want to follow, right? The state's basically usually just the minimum requirements, and then different municipalities or even different employers can go above and beyond that as they see fit. One thing that AB 2693 did do was it removed the requirement to report any outbreaks to your local health agencies, and that started in January 1st of this year. So as you recall, if you had what was considered an outbreak at your location, you had to contact your local health department or your local government agency that was in charge of that and make sure that was reported. That reporting requirement has gone away, at least according to the state guidelines. Again, make sure to see what your local requirements or local ordinance are, because that may still be required by your city. Another change that was could be seen as positive was as far as a notification of employees. How do you notify employees that there could have been an exposure at the workplace? And typically, the way it was done was by sending a letter, or even either a physical letter or an electronic communication to those employees affected, letting them know what was going on. There was plenty of templates flying around. We had one on our website that was free to anybody. I believe it's still there, of what this notification looks like, and the state provides one as well. Well, as of January 1st of this year, the state gives us the option of just posting the notice in the place where employees can customarily see notices. So one place that comes to mind is where you post your labor law poster, right? So what this allows you to do is, instead of having to send those individual notices to every single employee that was affected, if you had an exposure at the workplace, you could just, make one, keep a template, post that notice for 15 calendar days, and that would be compliant with it. Of course, you also have to log the dates that the notice was posted. So maybe that could mean keeping a soft or a physical copy of it separately with the dates that you posted that, right? Something to keep in mind too is if you're still distributing the notice to all employees, it's got to go to everybody on the premises or at the same work site during the infectious period, right? So anybody that was at that work site when the infectious period occurred, those are the ones that have to receive notification. If you're distributing them individually, if you're posting it, just make sure you post it at a location where all employees can frequent, whether that's your break room, whether you have a bulletin board, whether you have, somewhere where you post all these notices. That is where you want to place them. Now, when it comes to what is required of this notice to the worker, of course, you want to make sure that you're including the dates where the exposure took place, location of the exposure, whether it was a specific work area, whether it was a specific office, a specific building or location. And then you will list the contact information where they can receive additional information regarding benefits, testing, what the clean disinfection plans, what your COVID prevention plan is. Make sure you include any anti-retaliation or discrimination protection information on there, or contact information for that as well. One thing we are not going to do is we are not going to give specific information on who the person that exposed them was, right? We're not listing, on January 5th, Fred came to the office and tested positive the next day or what have you. Again, that is still, private protected information that we do not want to share. So all we're giving is a very general notice saying, on this specific date, you may have been exposed to COVID-19 or someone that tests positive for COVID-19 virus. And, these are your rights, these are your precautions, and these are our policies for it. Okay. And continuing on with COVID and the workplace, our next measure that passed or that affects us is AB 1751, which relates to COVID and workers' compensation. Now, this is another one that extended provisions until January of next year. And again, this one basically can classify a outbreak at the workplace as a workers' compensation situation, right? Or if someone can attest that they got COVID at your workplace, that would be eligible for workers' compensation coverage, right? And now there is it's a presumption that employees are eligible for workers' comp if there's an outbreak, during the time where they got COVID. And the definition of outbreak, of course, is if you're in a location that's 5 to 100 employees, if 4 employees test positive within a 14-day period, that's considered an outbreak. Or if you have 101 plus employees, so if you have more than 100 employees, if 4% of your employees test positive within a 14-day period, that is considered an outbreak as well, and could be considered an outbreak for any workers' compensation claims by employees going forward. So employee can say, I caught this illness at work, there was an outbreak going on. And, the presumption would be that, yes, since there was an outbreak going on and they acquired it during this time, they are eligible for workers' compensation. Now, keep in mind, this is a disputable presumption, which means the employer can present evidence that if they believe that the employee did not acquire the COVID virus at work, or they did not get sick because of work, and they have any proof of that, they can present that evidence to contrary. However, the presumption is that it was acquired at work if there was an outbreak going on during that time. Some other changes that were made was the change in the definition of what a close contact is. And if any of you have kept up with the developments with how the state has dealt with COVID in the past couple of years, that these changes tend to come fairly regularly. So the latest change to this was how close contact was defined. Initially, it started as, if you're within 6 feet of or 10 feet of somebody, or within 6 feet of somebody, or so on and so forth. And that definition just kind of evolved throughout the life of the situation or the life of the pandemic. So now this is the latest definition of what a close contact is. So this is, keep in mind, this for indoor spaces. So if your indoor space is 400,000 or fewer cubic feet per floor, and some examples, this could be the home, clinic, waiting room, an airplane, that sort of thing, then anybody that shares the same indoor airspace as the infected person for a cumulative total of 15 minutes. So it doesn't have to be one 15-minute period. It could be a cumulative total of 15 minutes, 5 minutes here, 10 minutes there, whatever, over a 24-hour period. That is defined as a close contact. Now, if you have a location that's greater than 400,000 cubic feet, so I'm thinking open floor, office plans, warehouses, large retail stores, that sort of thing, then this is more the typical definition that we're used to, right? The 6 feet for a cumulative total of 15 minutes during a 24-hour period. And again, keep that in mind, it's cumulative. So it's not just, 15 minutes at a time. You can't stand next to somebody for 14 minutes and 30 seconds and then walk away and, have it not count. Because if it adds up to 15 minutes throughout the 24-hour period, then it would be considered a close contact. And again, you know, a lot of the other requirements are still there when it comes to quarantining, to wearing masks, that sort of thing during exposure. So make sure that you know, you didn't just throw out your COVID prevention plan when the new year rolled in. Those plans are constantly evolving, and again, it could be something that will more than likely not go away. You know, it'll become a part of our how we do business, much like our injury and illness prevention plan. You know, we'll have a COVID prevention plan that goes along with it. Going forward, it could be something else. It could be like an infectious disease plan or something, but you know, this is something that chances are will not go away from us. Another interesting change that was signed into law last year was SB 1044, which relates to emergency conditions. And, you know, given what we've seen since New Year's here in California, especially in Northern California, this is very timely information, right? So, you know, this was brought about for any condition that we see a lot of in California: wildfires, floods, that sort of thing. And basically what this states is that an employee cannot take any adverse action against an employee, or an employer cannot take any adverse action against an employee for refusing to report to work or leaving the work site when they have a reasonable belief that it's unsafe. So for example, if you're in a location that is actively flooding, or there's a forest fire nearby, or that sort of thing, and your employee says, I don't feel safe, I need to leave, you know, or there's a fire near my child's school, I need to leave to attend to them, then you should not take any adverse action against them, you know, whether that means giving them a point for attendance or counting as an absence or what have you. You know, this is an additional protection for that. Additionally, this protection extends to accessing their mobile device or communication device, you know, to look for emergency assistance, communication, that sort of thing, right? So this doesn't mean that it's a free pass for everybody to walk around looking at their phones all day, right? This is just during an emergency condition. So if you know, if you're in a situation where there's a weather event at your location, you know, I know we've gotten tornado warnings recently, that sort of thing, then you know, if you think about it, our phones, our mobile devices, that's where we get most of our information. That's where we communicate with loved ones. That's where we, you know, seek help. You know, you should not take adverse action against somebody for using their communication device during those situations. So there's going to be, as you know, you're going to want to take a look at your cell phone policy and see how it affects it, right? I mean, again, this is not a free pass for everybody to use their phone as they see fit. It's mostly through any of these emergency conditions. So think things like, again, you know, floods, wildfires, active shooter situations, violence in the workplace, that sort of thing. Those can all be situations where it would be reasonable to assume that somebody is going to use their phone or their communication device to ask for help. One thing this law specifically excluded was, or addressed, was any pandemic or illness, right? So you know, a big concern was, hey, well, what if my employees call in and say, you know, we're afraid of COVID and we don't want to come into work. There's an emergency condition, you know, we don't want to come into work, and you can't take any action against us. Well, actually, the state, you know, took that into account, and they said that, you know, pandemic, any kind of illness or outbreak is not covered by this. This is more things they had in mind were, again, you know, things like wildfires, floods, active shooters, that sort of thing. Okay. So some takeaways from your first section: make sure that injury and illness prevention program and your COVID prevention program are updated as needed. Again, there's constantly changes going on. OSHA is, you know, still taking a look at the COVID prevention programs and making changes to on a regular basis. So, you know, tune in, try to stay up to date on those changes. Give us a call to see if there's any updates that need to be done. And again, you know, the IAPP and the COVID prevention plan, those should be living documents for you, right? This is not something where, you know, you kind of create a program 5 years ago and then put it on the shelf and forget about it, right? One reason for that is if you have a visit from any state agency, you know, think OSHA or any other kind of agency, one of the things you're going to ask you for is, hey, can we take a look at your injury and illness prevention program or your COVID prevention program? And if those things are out of date, if you have people listed on there that are no longer with the organization, that's usually a big red flag and could lead to issues. So again, you know, just make sure you're taking a look at those at a regular basis, whether it's every quarter or every couple of weeks, you know, anytime there's a change in your personnel, make sure you're updating them as necessary. Think about how you want to do the COVID notifications, right? Are you going to continue to send individual notifications to everybody, or are you going to go to the posting model? So again, both have their advantages and disadvantages. Take a look to see what works best for your situation and how you're going to execute that. Keep reporting those COVID cases to your workers' compensation carrier within the 3 business days. Again, that was one of the requirements. Within 1 day, you have to notify employees of an exposure, and within 3 days, you want to notify your workers' compensation carrier. And again, this is just a notification. This doesn't have to be a claim. A workers' compensation claim. You're just notifying them that there was a COVID case at your workplace. That way, it helps them monitor the situation as well. Have communication with your workers' compensation carrier if you haven't done so yet, to see how they are going to manage these reports. Early on, when this became a requirement, a lot of workers' compensation carriers were taking these as incidents, right? And they may not always be incidents. They may not always be considered incidents. They may just be a report sometimes. So just make sure, have that conversation with your carrier to see what their preferred method of reporting is. Maybe there's an email method to do it. Maybe they want you to call. Maybe they have a portal. So kind of explore that to see what the best way to do it is. And finally, if you're a CA member, we do offer a COVID exposure toolkit that kind of walks you through what the process is to work through that exposure, what notifications to do, what the steps are to get through it. All right, our next section, we will deal with some industry-specific updates, and some of the things we're talking about will be fast food, agriculture, and call centers. Now, some of these were very well publicized changes, others kind of snuck up on us. So let's talk about them a little bit and see how where they stand as of today, right? So the first one was the AB 257. That's the Fast Food Council, also known as the Fast Recovery Act, right? And this is one that was basically going to create almost like a bargaining unit for the fast food industry. This was signed into law back in September 5th of last year. And as you can imagine, I mean, there was a lot of back and forth on this one. So initially it was supposed to go into effect on January 1st of this year. However, at the 11th hour, there was a court order basically holding off on it until January 13th, which was when the court was going to take a look at it again. So that was last Friday. Superior Court took a look at it again and actually granted a preliminary injunction to prohibit the DIR from implementing AB 257. So this one is on hold. That's where we are right now. It's on hold. But however, I mean, think of the impact of this one, which is the reason why there was so much back and forth on in the courts, was this basically took an entire industry, right, and gave them a bargaining unit. So some of the things that they were looking at were looking to change work conditions or minimum wages, right? There was talk of minimum wages going up to $20 to $22 an hour range for any of these fast food chains. So again, this one, where it stands right now, is it is still on hold, pending additional litigation and a ballot referendum. So as you would expect, there's a lot of challenges to it. So this one has not gone into place yet. It is still on hold. We don't expect it to go on hold in the near future, but stay tuned to see where it goes. Another one that had gone back and forth for a bit and was finally signed last year was AB 2183, which was the Agricultural Labor Relations Act. And this is one that was supported by the United Farm Workers Union quite a bit, and it had gone back and forth with Governor Newsom for several years going forward, right? He definitely not signed it until he finally signed it last year. And so this one basically has gone into place for the next 5 years, which changed the way that basically ag labor elections take place. So this was a huge victory for labor unions. And what it did was it basically now gives agricultural employers 2 options. The first one is to enter into a labor peace compact. And what that means is that the employer won't have any statements for or against the union or conduct any captive audience meetings, right? Basically, that means the employer is going to kind of sit back and let the situation develop without actively using some of the tools available that were available in the past to fight unionization. If the employer does not or opts not to be under a peace compact, then that allows a union to just submit authorization cards signed by a majority of employees to be certified. So it means that doesn't have to go into election anymore. As long as they have authorization cards by the majority of the employees that are interested in the union, that would be enough for it to be certified and recognized as to represent the workers. So if you are in this industry, our best recommendation is, talk to your labor relations specialist. We do have the one that we work with very closely at CEA, or that's part of our team. So if you have any questions about that, if you find yourself in that situation, talk to a labor relations specialist to see if you should enter that labor peace compact or what the best option for you is. And again, I mean, this law set to sunset in 2028, but we're still waiting to see what the big ripple effect of this is going to be. Our next one relates to call center employees, and that's AB 1601. And what this law basically does is it's basically affects any closing call centers, right? That employ 75 or more persons. Now they are subject to the Cal Warn requirements before a mass layoff. And a mass layoff is, basically sort of layoff during any 30-day period of 50 or more employees at a covered establishment. Or relocation would be the removal of all or substantially all the industrial commercial operations in the covered establishment, right? So basically, if you have a call center that's closing, if you have a call center that's moving, if it's gonna, upend or change a lot of the employment in that area, then now that call center has to abide by the Cal Warn notices. And that means that, you have to give a 60-day advance written notice to employees and to the EDD if there's going to be a mass layoff, if there's going to be a closure, that sort of thing. So again, this is something that may be new to anybody running call centers, but just, a lot of other industries have been under these requirements for Cal Warn notices. So the tools are out there. So, and again, what's the stick that goes along with this? What if we don't comply with it? What if we just close our call center and move on? Well, unfortunately, if you fail to comply, it could affect your eligibility for state grants or state loans for 5 years after the date of publishment. So again, this is again one of those things where there is a penalty for not abiding by it. So again, if you are an employer that has a call center, or that is your business, make sure that you're aware of what the Cal Warn requirements are if you're going to have a mass layoff, if you're going to have a closure, move, or whatever it is. So some takeaways from this section. If you're not sure if you're a covered employer for any of these laws, am I agriculture? Am I not? Am I a call center? What is it? Consult your legal counsel, right? They will let you know, which ones of these affect you, how they affect you, and what is the best course of action for them. If you are a franchise, or if you have a franchise, if you are in the fast food restaurant industry, keep an eye out for that to see where it goes. There's a ballot referendum coming to see if that 257 is going into law or not, that Fast Recovery Act. So just stay up to date on it, see where it goes. For the time being, again, it's on hold for the time being, pending to see what the courts do. So let's see what happens with that. For agriculture, again, contact your local labor or your labor relations expert or counsel to see if you're going to agree to that labor peace compact or not. See what your options are, what the best course of action is for your organization. And finally, if you're a call center, have a template ready for those warn notices and be familiar with the process, right? Give yourself a timeline to make sure you're making those notifications on time and, sending them out to everybody. So it just means a little bit more planning ahead, unfortunately. And I see Mary came up here. We have quite a few questions actually that came up.
Well, Eli, all of our attendees get an A+ for their questions because
Excellent.
we've got a lot of really good ones. Let's see, I wanted to address a couple because I thought other people might be thinking about this too, especially because we've just come through, our atmospheric tidal cyclone wave, whatever the heck we were all
Right.
dealing with. And the cell phone use and emergencies situation. So we've had a couple people say, can I still have a policy that employees must keep their cell phones in their car and they can't bring them into the workplace? I think, yes, you could still have that policy, but if an employee says, I want to go to my car to get my phone because I'm worried for whatever reason, I would certainly allow them to go.
Absolutely, absolutely.
Yeah. And then we had another question saying, so if an employee leaves due to an emergency, can we not take vacation time away from them, or can we not deduct their vacation? Now, this is one of those where I would say it's a brand new law and we haven't had a lot of testing of this law. I would think if you have, again, a consistent policy that says anytime an employee takes time away from work, available vacation will be deducted. I would not do that with PTO or PSL ever. If your PTO includes your PSL, but if you have a standalone vacation policy and you have a consistent policy that says anytime that you take off from work, your vacation, available vacation will be deducted, that would probably be okay. But again, we have not had this tested in the courts. I mean, it's so brand new. So I would be cautious with that. But as always, I would be consistent with that. So,
Yeah, definitely are on the side of caution. And usually, I mean, these situations we will publicize, right? Whether it's, again, flood, fire, that sort of thing. So err on the side of caution on that. I mean, if you have those policies in your handbook, or even if you don't have the policies, it's maybe the time to think about putting them into place. But I would not, drop the hammer on somebody right now, because it's just too early in the process to see where they're going to go.
yes, absolutely. And let's see. Oh, and then we had another question come up back to transportation and the mileage reimbursement. So if an employer provides transportation, but an employee refuses it and wants to use their own vehicle, does the employer still need to reimburse that employee who's refusing the employer provided transportation?
That is an interesting one, because they're still using their vehicle to their detriment, to the advantage of the business. So I would believe that they should still be eligible for it, especially if they're using it for business purposes. I mean,
that's a tricky one. And and then I kind of suggested I would find out why they don't want to take the employer provided transportation, just to make sure there's not some sort of issue with a crew member or something like that. But I would be cautious with that. That might be one worth consulting with legal counsel on putting together a policy on that.
Absolutely.
Be careful, because in California, when in doubt, pay it out is kind of the safe standard. But might be good to get an outside opinion on that too. So, all right, absolutely. I'll turn it back over to you. Thanks.
All right. Thank you, Mary. Thank you. Great questions, great participation from everybody. Really appreciate that. Really keeps these moving. So in the next few minutes I have with you, I want to take a look at our crystal ball here, see what is coming up for California employers. Now, no need to panic on these yet. This isn't something that's going to take, place next week or after lunch or, next month or anything, but we're just looking ahead to see what changes are coming for us. And the first one, we keep going back to COVID. We can't get away from it, right? It's like that relative that won't leave your couch after a holiday. So what we have here is, OSHA, as I said, keeps meeting, and they are looking to transition what they call the ETS, or the Emergency Temporary Standard, into a permanent COVID standard. Again, this is something that is going to stay with us, not going anywhere anytime soon. So we're waiting to see what the state approves, and this could take up to 30 days from now. So we're going to see what changes they make. But one of the things we're looking for is, if they do approve the new permanent standards, we could see exclusion pay obligations go away. So that could be great news for employers, right? But stay tuned. We'll see once the permanent COVID standards come out, see what the changes are. So that should be coming up later on this year. Just stay tuned to see where that goes. And the next one that I hadn't mentioned earlier, but they had a lot of fanfare last year, was the AB 2188, which was additional protection for cannabis users. Now, the reason I mentioned earlier was because this is not set to go into place until January 1st of 2024. And what this does is it provides, FEHA provides protections for off-duty cannabis use, right? So what this means is employers cannot discriminate or take adverse action against employees for using cannabis off the job and away from the workplace. So think of it as they're taking the approach to cannabis similar to alcohol, right? So what this means is, you can't be under the influence, you can't be in possession at work, but if you choose to do it on the weekends or away from work or whatever, employers should not take any adverse action against you for it. Now, there's other things that could supersede it. For example, if your industry is governed by DOT standards or federal transportation safety standards, of course, those standards are going to supersede this. But for all other employers, this is a new protection coming up. So what's that mean? One of the questions we get was, well, should we stop testing? What's that mean for my drug testing? What's going to change? So goes to the old saying, you got to build a better mousetrap, right? So what I believe we're going to see here in the upcoming year is different tests, different ways of testing for cannabis use to see that can be used by employers or by their clinics to see if somebody is under the influence. So again, this is something that'll be evolving throughout the year. So stay tuned for more details throughout the year to see where it goes. Okay. And we did have a survey. Not sure if it's going to work. So I will just ask everybody, for you and your organization, do you currently conduct drug testing at your organization? You could just throw a yes or a no in the Q&A bot or in the chat for me. Let us know, are you testing? I know, I've been part of organizations that have decided, hey, you know what? It's hard for us to get candidates. We're not going to test for pre-employment. We're only going to test for, reasonable suspicion. We're only going to test for this or that. So there is a lot of different situations, and different things you could do. So, and I see, I see quite a mixed bag of responses, right? There's some yeses or some nos. Some people only screen for certain things and not others. Sometimes it depends on the position. So, it's one of those things where it really does depend on your organization, your policy, what industry you're in, right? Again, you could be governed by federal standards that say you do have to test or not. So thank you for your responses, everybody. And again, this is something that we'll see some movement on in the upcoming year. Okay. So a few final reminders for you before we wrap this up. It's employee handbooks change time, right? We got a lot of requests at the end of the year, but there have been some changes for 2023. Mary mentioned the designated person section for CFRA. So there is some changes to be made to handbooks. So if you haven't taken a look at them since last year, or if it's been a couple of years, now's the time to do it. Get it up to date, make sure it's compliant, get it out to your employees. Make sure you have your posters up, or at least ordered, right? I know sometimes they get back ordered. Usually, if there's an inspection, as long as you could show that you ordered them before the beginning of the year, you're in good shape. But if you get them, make sure you fill them out, put them up on the wall. Don't let them sit on your desk or anything. Any minimum wage changes, make sure that you are paying at least that minimum wage, that $15.50 rate, and that your exempt salary increased as well, right? There was some people that were right on the cusp of that exempt salary range, and maybe the new one leapfrogged them. So make sure you make those adjustments, either increase that salary or convert them to non-exempt employees. And finally, update that IAPP and COVID prevention plan as needed. Again, OSHA should be making some updates to that periodically. So, excuse me, make sure you're keeping up to date with that and updating those changes as needed. You could follow our blog. We usually send out a quick and timely information whenever these changes come through. And if you would like to become a member, we do offer different membership levels or membership plans for you. Here on the screen, you can see we have our ultimate members, premier, and then associate. And the nice thing about the associate membership is if you're not sure, you kind of like what we talk about, maybe you like Mary, but you didn't like me, that sort of thing. Well, you can decide, hey, I'm going to take this organization on the test drive. Maybe I'll do it on a month-by-month basis. So we do have a month-by-month program for associate at the associate membership level that you can try to give us a shot. So with that, I will go one more screen over and hand it back over to Tara so she can bring us home, unless we have any more questions out there, Mary, before I forget.
Well, we've got a flurry of questions.
A flurry.
A flurry, mostly about drug testing,
Mm-hmm.
because this is a tricky one. So what I would just remind everybody is this is not in effect yet. It's supposed to be 2024. Will this be delayed? I have my suspicions it might be, because we're not really sure all the tests exist that would make this a viable law. So we'll have to see. So you don't have to worry about changing any of your policies right now. Just keep up to date with our newsletters and keep a look on our emails that we send out, and we will certainly let you know if there are any changes. So you can keep your policy as is. You can still do reasonable suspicion testing. You can still do post-accident testing as part of your reasonable suspicion investigative process. So go ahead and stay the course for now, and then just keep an eye on this for 2024. And
Absolutely.
I think I'm caught up with the rest, but if we missed anything,
All right.
that's what the hotline's for. So give us a ring. We'll be happy to chat with you there.
There you go. Well, thank you all. Let me pass it over to Tara with the next slide for us.
All right. Well, thank you, everybody. Thanks for all the great participation and questions. We always really love that. Eli and Mary, as always, such great information and so much packed into an hour and a half. Excuse me. We do have some continuing education codes. The HRCI code is 615386. And the SHRM code is 23 dash. And as Eli would tell you, you can't forget the dash. And it's SJJHS. I'll go ahead and throw those in the chat box as well, so you can just grab those. Again, I'm putting the hotline number in just so you have that as well. Another reminder really quickly is that we have a survey slide here. If you would just take a quick picture of that, that QR code, then you can just take the quick survey. It'll take you 30 seconds of that, because there's only 6 questions, but there's 6 questions that we really would love to hear from you about how we're doing and what we might be able to do better, or how great we already are. And last but not least, this webinar was recorded, and I'm putting into the chat box. It will be on the Riverside County YouTube's channel. Jason was gracious enough to find that and to give it to us, so I just put that in the chat for you as well. I don't know if it'll get uploaded until probably Monday or Tuesday, but you can check there. So with all of that said and done, thank you again, everybody, for being here. We really appreciate it. Again, if you've got any questions for us, please use that hotline number. We will see you again soon. We really enjoy Riverside County, and Jason, you're great. So thanks, everybody. Take care.
Thank you.